sassy and funny. I think I'm pretty funny. Ain't no gaming stream every night. I know, I'm so sorry. I think I have to indefinitely postpone gaming streams just until finals are over. I keep thinking like, okay, I finish one final and then I'm gonna have more time, but every time I finish one thing, more things keep popping up. 3 S's. Oh, what did I say? Sassy, salty, and what was the last one? That's cute. I should stick with that. I forgot. Sassy, salty, and oh no, not. I said funny, which is not an S. Gee, that's hard when she's lying. Dude, I am. I really miss gaming streams. Honestly, I'm more sorry for myself. Sassy, salty, and funny. It's not 3 S's. Oh yeah. I'm getting smarter by chance expense. I said funny, but we can find an S word. Okay, how about slick? No, I'm not slick. I'm pretty clumsy actually. Not slick at all. Okay, this is on. Go to Twitch, open up chat, and then go to Streamlabs, and then go to music, lo-fi. Sorry guys, no music requests today. I have to study, and whenever I have music requests on, the songs are so good I like get caught up in it. Jazz, Halloween, Jazzy Town. Let's try Jazzy Town. Stupid? Sorry, I had to say it. I love you, Karai. Oh my gosh. Oh, Karai, thank you. Welcome to the stream. Thank you so much for the follow. How are you doing this morning? Am I in the right category, guys? Lately, I keep stumbling over my words. I need to slow down. Oh, right, and I was going to announce to Discord that I will not be able to make a gaming stream. Discord is so funny. There's always so much for me to catch up on. Okay, announcements. John, thank you so much for the follow. Glad I'm volunteering. Thank you. It's something I always wanted to do, and I'm so glad that my school allows it. What's my full name and social security number? Even if I told you, you wouldn't believe me. Oh, you're doing great. Good to hear, Kurai. Am I saying it right? Kurai? Is my college in the North Bay? Honestly, I don't know the Bay. People keep saying North Bay, East Bay, South Bay, and I didn't even know what was Northwest South OC, and I lived there. I know I'm in the Bay, but even if when I do find out, I don't think that's something that I would want to announce, because I think it'd be very easy to pinpoint where like I actually am. And just give me your full name. I'll get your social off the Equifax hack. Oh gosh. Morning, Supreme. Oh right, and I was supposed to have Streamlabs open. What were we gonna work on today, chat? I'm not sure. Wait, is this like a little off? So sleepy today. Cheers, guys. Am I from Moscow? No, I'm not. I'm from the United States. I ain't stopping lemonade. Blink228, hello, how's it going? Um, oh, thank you, Supreme. I got this jacket from Forever 21 years ago, and it makes me really sad because I bought it and the button was missing, so then I had to roll it up, otherwise it's like super huge. And then now I always have to wear it rolled up, but I want to wear it like full sleeve. I guess I could like sew another button on it. Just have to learn how to sew first. Iowa, Texas, Argentina, what? Canada, States of America. United States of America. I'm from California. I go to Monterey College. Where's that? United States. California. Oh, music. Did it not play? Oh, this is so cute. How do I save? I'm gonna save this. I like it. So cheerful. I love cheerful music. I go to Wingstop College of Law. A Wingstop. Starts listing all colleges. Okay. Do I love you yet? I don't even know you. Good morning, Dee. It's so nice to have my iPad finally charged. Why is my Apple Pencil upside down? What is this? I don't understand. Why was it upside down? Weird. Very, very weird. Sorry, Blink. English only. Chat's interesting today. Yes, surprisingly, my laptop is still alive. I absolutely do not have money to repair it, so I think I'm just going to wing it and hopefully. Am I Korean? No, I am actually Vietnamese, but I get Korean mix or Japanese mix a lot. What are you trying to do with a law degree? Honestly, I'm just enjoying the education. I'm probably gonna do IP law or in-house law, but as for now, I'm really just enjoying learning all the case laws. As weird as it is, I love learning. Even Microsoft? What does that mean? You're multitasking, you're gonna learn. Alright, robot. Get the stream warmed up. Trial lore, let's go do it. Oh, no thank you. Oh, you like Vietnam? Have you been? I haven't been. Alright. Ouch. Let's actually read for class. I wonder what people think I'm doing. Like, they see me talking to myself. You see the guys in chat haven't learned not to mess with me yet. I'm a weird one enjoying education, right? I feel like a lot of people don't enjoy education, but I do. Are you girl me? Like men like, but girl, you know, but like men, what? I'm so sorry. I don't know what that means. I look crazy without talking to myself. Doubt it helps my image. And then I guess I look even crazier now, right? Hold on. This was practice. I got an A. I got an A, guys. It was just a practice test. But still, it makes me really, really happy. Thank you. 15% of the class gets A's. Any on what? Tort law. Just wanted to check in. You have to go. Class is soon. Study. Thank you, D. Have fun in class. What's my homework? I'm really liking this lo-fi channel. It's like super upbeat. Oh, John, thank you so much for the follow. I didn't catch that. Aw, it makes me sad when people follow me off a stream because then I don't get to thank them. But Sifo, thank you for the follow. I'm gonna start doing that. I'm just gonna start reading the follows even if it happened prior or post stream. Empty reviews and slides. Let's see how much homework I can actually get done today. Tell us all about tort law. I'm about to tell you right now. So tort law is cases between individuals or companies, and it's generally for monetary compensation. And today is, what day is it? November 13th. I normally do all my reading for the weekend before. Civil suits, yes. So are you in law? It's just that I don't want to say legal words to describe my law classes because I feel like even if I say civil suits, people who aren't knowledgeable about the law would say, well, what is a civil suit? Like, what is the difference? Copyright and all that? Not necessarily. Like, okay, let's say you take a baseball bat and you hit somebody. That could be a crime, like the state could prosecute you, but if you take a baseball bat and hit the person can also sue you. So there's there's criminal law, which is the state will prosecute you for the crime that you committed, and it's a social harm. It affects everybody else because you don't want random people going around with bats hurting random people. But it's also a civil suit between two individuals or a company or whatever it is, where there's a personal stake, and then you can seek personal compensation from that on top of the state prosecuting you for the criminal behavior. November 13th. Read Chapter 17, Assumption of the Risk, page 616 to 626. So it's pretty much going to be story time. I'm just going to read you guys a case. Assumption of the risk as an absolute defense. Express assumption of the risk. Dillery v. Sky Limited. Let me have my chat up first, though. Use legal words. Teaching helps you learn more than studying does. No, actually, teaching in your own words helps you study more than reading. So if I just keep repeating legal words, if I can't explain it in like simple terms, then I haven't really digested the information myself. That definition helps more? Okay, good, awesome. I'm glad it helped. Cheers for that, you're lurking. High five, guys. Okay, so while skiing at Killington Ski Area, plaintiff Robert Dillery sustained serious injuries when he collided with a metal pole that formed part of the control maze for a ski lift line. So this guy collided with a pole in a ski lift line. Before the season started, Dillery had purchased a midweek season pass and signed a form releasing the ski area from liability. The relevant portion reads, okay, so he signed a form releasing liability, which means supposedly he can't recover for injuries. I accept and understand that alpine skiing is a hazardous sport with many dangers and risks, and that injuries are a common and ordinary occurrence of the sport. As a condition of being permitted to use the ski area premises, I freely accept and voluntarily assume the risks of injury or property damage and release Killington Limited, its employees and agents from any and all liability for personal injury or property damage resulting from negligence, conditions of the premises, operations of the ski area, actions or omissions of employees or agents of the ski area, or from my participation in skiing at the area, accepting myself the full responsibility for any and all such damage or injury of any kind which may result. Dillery and his wife filed a complaint against defendants alleging negligent design, construction, and replacement of the maze pole. Defendants moved for summary judgment, arguing that the release of liability barred the negligence action. So this guy bumped into a pole and he was injured from it, and he's trying to sue the skiing company, but they're saying that he signed a waiver releasing liability to use their equipment, and now that's why they're raising it as a defense that he signed a waiver, like he can't sue for it. So the trial court based its decision on Douglas v. Skiing Standards Inc., in which we held that an exculpatory agreement was sufficient to bar negligence action by a professional freestyle skier who was injured in a skiing competition. The trial court did not view the distinction between professional and recreational skiing as significant and granted summary judgment on the ground of the release that the release was clear and unambiguous. So they're saying the trial court, the very first court that saw this, is saying that they're basing it off of Douglas, and there's no difference between professional and recreational skiing. On appeal, so then they rendered judgment for the defendants, so the ski company won, and now the plaintiff is the person appealing the case. They contend that the release was ambiguous as to whose liability was waived and that is unenforceable as a matter of law because it violates public policy. We agree with defendants that the release was quite clear in its terms. Because we hold the agreement is unenforceable, we proceed to discuss the public policy that supports our holding. Zaku, thank you so much for the sub. Happy 3 months. Thank you. Hello guys. Oh hey Mega Man. Hey Calchester. LA Kid, how's it going? Thanks for the explanation. Awesome. I hope this is fun. I'm gonna do it either way. Morning trippers. Are they saying that he knew the risks regardless of injury? Yes, they're saying that, so like when he bought the season pass for skiing, he signed a form, and on the form it says that you know the risk and you're not gonna sue for that risk. So then now he's injured and he's saying like, hey, I got injured, and they're saying, well, you knew the risk and you signed it. And then the argument here is that it's against public policy. Like a company can't just say they're not liable for anything, because then people would be hurt all over, and like someone has to be held responsible. So now we're seeing like because it affects public policy, like who should win, and then the reason these cases are important is because it sets precedent for following cases. So in the future. Wait, really? Yeah. So this is just like the intro to the case, and now they're going to explain like the reasoning and see who ends up winning. So this is a case of first impression in Vermont. While we have recognized the existence of a public policy exception to the validity of exculpatory agreements in most of our cases, enforceability is turned on whether the language of the agreement is sufficiently clear to reflect the party's intent. Even well-drafted exculpatory agreements, however, may be void because they violate public policy. According to the restatement, an exculpatory agreement should be upheld if it is freely and fairly made between parties who are in an equal bargaining position and there is no social interest with which it interferes. The critical issue here concerns the social interests that are affected. Your mom always told you not to invite friends to your house because if they got hurt, they could sue you guys. Yeah, that is an issue. It's not necessarily always true, but that is, like, we're a very litigious country, and people do sue for lots of things. Like, even if it's not your fault, it could be found that it's your fault. Your dad's gonna let you go out with friends even though you're 19. Oh, Boom, I'm sorry about that. At least we can be friends. So this is a skiing accident. Ski pole accident. Release of liability, negligence, exculpatory, was clear, but public policy usually every time I read like a page, I try to put like a post-it note of like the main ideas, and it really is like the act of trying to summarize what I just read in a couple of words helps me process and retain the information, and that's usually like how I study. Forgas, thank you so much for the follow. Didn't someone sue Red Bull for not giving him wings? I think they did. What kind of lawyer do I want to be? I want to be in intellectual property, trademarks, and patents. You don't need the baby seats at Red Lobster anymore? Wait, what are you saying about old enough to get off the car seat? Oh, about being 19. So courts and commentators have struggled to develop a useful formula for analyzing the public policy issue. The formula has been the subject of great debate during the whole course of the common law, and it had proven impossible to articulate a precise definition because the social forces that have led to such characterization are volatile and dynamic. The leading judicial formula for determining whether an exculpatory argument violates public policy was set forth by Justice Toberner of the California Supreme Court. An agreement is invalid if it exhibits some or all of the following characteristics. Factors for invalid agreement. Factors for invalid agreements. It concerns a business of a type generally thought suitable for public regulation. The party seeking exculpation is engaged in performing a service of great importance to the public, which is often a matter of practical necessity for some members of the public. The party holds itself out as willing to perform this service for any member of the public who seeks it, or at least for any member coming within certain established standards. As a result of the essential nature of the service and the economic setting of the transaction, the party invoking exculpation possesses a decisive advantage of bargaining strength against any member of the public who seeks the party's services. In exercising a superior bargaining power, the party confronts the public with a standardized adhesion contract of exculpation and makes no provision whereby a purchaser may pay additional reasonable fees and obtain protection against negligence. Huh? Why you write so much shit for? Finally, as a result of the transaction, the excuse me. Oh, you're gonna hit me up later to get your logo trademarked? I should be a divorce lawyer. There's always going to be divorce. I don't think that's fun. I wouldn't want to sit in a room with people fighting all day. You Asian? Bless. Thank you, John. Person or property of the purchaser is placed under the control of the seller, subject to the risk of carelessness by the seller or seller's agents. Applying these factors, the court concluded that a release from liability for future negligence imposed as a condition for admission to charitable research hospital as invalid. Numerous courts have adopted and applied the Tunkel factors. Oh gosh, I think I have to learn these factors. Tunkel factors. Tunkl. Tunkel factors. Yeah, I want to sit in a room with big companies fighting all day. Is that what you think law is about? Applying these factors, the court concluded, that you are respectful of your parents and stuff. That's recreational activities with students, it fulfills its education mission, and performs a public service. Other courts have incorporated the temporal factors into their decisions. The Colorado Supreme Court has developed a four-part inquiry to analyze the validity of exculpatory agreements. 1. Existence of a duty to the public. 2. Form 3. Whether the contract was fairly entered into. And 4. Whether the parties expressed unambiguous language. In the Jones case, the court concluded, based on the temporal factors, that no duty to the public was involved in air service for a partial jump because that sort of service does not affect the public interest. Having reviewed these various formulations of the public policy exception, we accept them as relevant considerations but not as rigid factors that, if met, preclude further analysis. Instead, we recognize that most of the public policy issues in every section of context. So, the past few cases that have gone to court have used different factors to analyze liability, but the court does extremely mainstream these factors, and the court has been up to their own. Just me, trademark lawyers sitting in office all day submitting forms. Yeah, that's actually what I did. The trademark paralegal. Submit forms all day, and I had so much fun. I'd be like on one of those drama law women, like who? Defendants urge us to uphold the exculpatory agreement on the ground that ski resorts do not provide an essential public service. They argue that they overruled plaintiffs to permit them to use their private land for skiing, and the terms of the agreement has to be left entirely within their control. Because skiing, like other recreational sports, is not a necessity of life, defendants can use the ticket is a purely private matter. Whether or not defendants provide an essential public service does not involve any policy question in recreational sports context. The defendant's area is considered open to the public. Facility open to public. Thousands of people ride lifts, buy services, and ski the trails. At oral argument, defendants conceded that thousands of people buy lift tickets every day throughout the season. Each ticket sale may be, for some purposes, a purely private transaction, but when a substantial number of such sales takes place, as a result of the seller's general indication to the public, realize the facility's purpose in question, legitimate public interest arises. Imagine getting to an argument with me and I start pulling out documents, presents evidence in a strong debate. Oof. I actually used to be extremely argumentative when I was younger, and now I'm really not the opposite of argumentative. If somebody wants to argue with me, I just walk away. Wonder who won the case, the company or the guy that got hurt. I know, I'm still reading about it. The major public policy implications are those underlying the law of premises liability. In Vermont, a business owner has a duty of active care to make sure that its premises are in safe and suitable conditions for its customers. We recognize this duty of care where the defendant's routine business practice creates a foreseeable hazard for its customers. The business invitee has a right to assume that the premises, aside from the obvious dangers, are reasonably safe for the purpose of which he is upon them, and that proper precaution has been taken to them so. We have already held that a ski area owes its customers the same duty as any other business to keep its premises reasonably safe. So, premises liability, reasonably safe. premises liability, business invitee should expect a reasonably safe place. Giant cup for a tiny person. Oh my gosh, it looks huge, huh? It's normal. If you want to argue with me, you have to pay money for my time. I really don't like arguing. I mean, debating is fun, but I feel like arguing has that negative connotation, and people start using like ad hominem arguments. They start attacking you about things that aren't even relevant, and it's just unnecessary. The policy rationale is to place responsibility for maintenance of the land on those who own or control it, with the ultimate goal of keeping accidents to the minimum level possible. Defendants, not recreational skiers, have the expertise and opportunity to foresee and control hazards and to guard against the negligence of their agents and employees. They alone can properly maintain and inspect the premises, train their employees in risk management, blah, 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 blah. The defendants were permitted to obtain broad waivers and achieve incentive. An important incentive for ski areas to manage risk would be removed if the public bearing the cost and results of injuries. Broad waivers lead to Iron Beast, good morning. If someone starts using any logical fallacy, they won the debate, period. True. Thanks for the follow, dude. Broad waivers would lead to an important incentive for ski areas to manage risk would be removed. Would lead to ski resorts not removing risks and public bearing cost. It is illogical in these circumstances to undermine the public policy underlying business invitee and allow skiers. A recognition of the principles underlying the duty to business invitees make clear the inadequacy of relying upon essential public service. Moreover, reliance on the private nature of the defendant's property would be inconsistent with societal expectations about privately owned facilities that open to the general public. Indeed, when a facility becomes a public place of accommodation, it renders a service which becomes a public interest. Place of public accommodation. Defendants argue that the public policy of the state, as expressed in the acceptance of inherent risk statute, indicates a willingness on the part of the legislature to omit ski liability area. Therefore, they contend that public policy favors the use of express releases. On contrary, defendants' allocation of responsibility for skiers' injuries is at odds. The statute places responsibility for inherent risks of any sport on the participant, insofar as such risks are obvious and necessary. A ski area's own negligence, however, is neither an inherent risk nor an obvious and necessary one. Thus, skiers' assumption of the inherent risks of skiing does not abrogate the ski area's duty to warn of or correct dangers. The company lost. Thou shalt not commit logical fallacies. Good morning, Josh. How are you doing? I'm frozen. Are you guys there? My screen is frozen. Y'all there? Hello? I am there, right? Okay, I think so. Just kick a tree in his gameplays. Not necessarily that. My internet be wildin'. I know. I don't know why. I had to check my phone connection after stream. And maybe I'm signed into like the wrong network. Good morning, Emperor. How are you? My face is frozen like Asian jeans. Oh no. The company lost because they can't just have a big liability waiver and not be responsible for injuries occurring on their premises if it's something that they could have taken care of. And because a ski resort is a private place, but if you open it up to the public, now it's a public place of accommodation, so then you have to, how do I explain this? Yeah, so now that it's a public place of accommodation, then it's a matter of public interest, and they want like safety standards. When does my day end today? My day or my stream? Am I still frozen? It's like really bad. Shit. My FPS is like 20 something. Good, you're off, so you're gonna sleep in, but your pupper's going crazy. Aww. It just glitches every now and then. I'm sorry guys, I will fix my connection for next time. But if I fix it now, I think I'll be gone. Just a stutter from time to time. Sorry about that today, guys. I love puppers, me too. Me too. So this one is Senior V National Fitness Institute, Inc. I'm tired of reading out loud. Let's put a pin in it. Thanks for being understanding, guys. Vanish, hey, how's it going? Okay. Oh. Revise towards syllabus. Oh no. Why? Which means more homework. Please note that I've added document 17-0A to chapter 17 of the Kane folder. It is on vicarious liability, and I plan to cover the material at the beginning of next Monday's class. Leaves home because I won't get as much done. Proceeds to distract herself with stream. I know, it's so bad. It's okay. I think we got one case done. Oh my god, it's 8:47. Did it take me 47 minutes to read one case? That's actually pretty bad. Supplemental jurisdiction. If supplemental jurisdiction is solely on 1332, then jurisdiction except if rules 14, 19, 20, or 24. Res judicata, one and done. A matter adjudicated once cannot be pursued further by same parties. I should host someone at end of stream if I want. I should start doing that actually. Thanks for being your lawyer. I keep forgetting the coffee positioning, my bad, you guys. Yesterday, Razor Cortex was reporting your FPS is like 3. Oh gosh. If you have any friends that you want me to raid, let me know. Yeah, the rule of thirds. Okay. I should work on my outline. Yes, my outline. What am I gonna do when my laptop dies? No, my laptop is not going to die. Contracts, outline. Hello? Okay, there it is. And also chart. Contracts rules. Not most wanted. Hey! Good morning, how's it going? Not most wanted. Who else can teach us about the law? Have fun hanging out. Thanksgiving dinner. Oh, thank you. It's gonna be great. I'm really looking forward to it. Not most wanted. Thank you so much for the follow. Hey, dad joke. Did you laugh? Totally. So you'll never have like a mock trial or anything yet? I don't know. I thought about doing it for extracurricular activities, but it's not really my thing. At you, not with you. Ouch. You're hilarious. Ha. You guys ever go LOL and you're just sitting there like, or you go LMAO and you're like texting, but like you're just sitting there and you're not laughing? I messaged one of my friends in class and he put LMAO and I looked at him and I was like, you're not laughing, I'm staring right at you. You fucking liar. So, outline time. Yeah, every time. Exposed. Super exposed. We'll see. I'll update you if I end up trying it out or not. If you type LOL, that means you're laughing, period. My book is so fucked up. Hello, chat. There you are. What was I reading? I don't remember. Hey, Deb. How's it going? If you type LOL, you're not laughing. If you type LOL, then you're laughing. So that book is basically full of trials. Yeah, it's a case book. So it's full of past cases that we're exploring, and then it sets a precedent for future cases. What am I studying? I'm a first year law student, and I was studying tort law, and now I'm studying contracts. You're a media guy. Ooh, nice. What do you do? Do you film? I don't know very much about media. Where's my internet? You're trying to understand this because it's pretty applicable. Precedents can be thrown out by the judge of a higher court, though, right? Depends. Yeah, it could possibly be thrown out. It could be modified. So, oh, mistake. Did I put 376 in here? I did not. 376. And 376 is, so I have like charts and outlines of like my course material that I kind of have like that I do to take notes, I guess. So now I'm just updating my stuff. Availability of damages. How is school? School's great. I love school. I'm having a fun time. You do video editing, but you want to try film. Oh, I see. Oh, no worries. That's cool. Adult film media, for sure. Emperor. 208. Wait. The injured party has a right to damages for any breach by a party against whom the contract is enforceable unless the claim for damages has been suspended or discharged. If the breach caused no less... I'm dropping frames still? Keeps happening. Your Wi-Fi be trash. No, I really think it's mine. If the breach caused no less, or if the amount of the loss is not proved under the rules stated in this chapter, a small sum fixed without regard to the amount of loss will be awarded as nominal damages. If the breach caused no loss, or if the amount of loss is not proved. Okay. So, injury equals damages, and then nominal damages. Got it. Want to come over and study? Did you know when people ask you to come over and study, they don't actually want to study? I can film and edit, right? Because you film and edit. Netflix and chill. People are fucking liars, dude. Like, you didn't want to study. I'm going home. That's also happened with, hey, you want to watch a movie? I'm like, yeah, oh my gosh. Now I'm just like, I don't watch movies. Study anatomy, what do you mean? I'm not a science major. I don't need to study anatomy, thank you. Insert rows below. That is. You never want to study, you're just trying to get some ramen. Oh, I love ramen. I fucking love ramen. I fucking love ramen. Hey, wanna watch a movie? Never. I actually don't like movies. I like books. I like some Netflix shows, but I don't like movies. I can't sit there for 2 hours. Unconscionable contract term. Or term. And what does that mean? If a contract or term thereof is unconscionable at the time the contract is made, a court may refuse to enforce the contract, or may enforce the remainder of the contract without the unconscionable term, or may so limit the application of any unconscionable term as to avoid any unconscionable result. What the fuck does that mean? You think study anatomy together is a euphemism? I didn't know that a lot of the time. Want to read a book together? Oh my god, yes! I actually have book clubs with my friends, and we would read the same book, and then we would talk about it. And we'd ask each other like, hey, did you get to this part yet? Okay, let me know when you get there. And then like we'd talk about it. Damn it, Upper. Almost spat coffee on my screen. J-Pop, thank you so much for the follow. We are not studying hard law. 50 Shades of It's an Asian thing. You guys are terrible. You guys are the reason why I don't study with people. Illegality, 178. Insert columns below. 178. Yo, type. I need flashcards. When a term is unenforceable on grounds of public policy. When a term is unenforceable on grounds of public policy. Wait, UCC 3, 175 and 176. Oh shoot. Insert rows below. Insert rows below. 175. Who is Soyu? Oh my god, it's one for you. I totally forgot, Boom. Chat's super busy in Lou today, right? If there's something that is deemed unreasonable in a contract, the court can void said contract. I think that's what it's saying. Ah. Like if a contract said, you're my slave now. It's Wednesday, my guy. Most active chat, no doubt. Adult novels. Are we really doing this? Boom, a real... I know, Boom, you're a real one. My god, you guys are wild today. Bye, robot. Thanks for hanging out. 175. When duress by threat makes a contract voidable. We did go over that. When 175. When duress by threat makes